A really warm welcome to you all. This is my first presentation back from maternity leave, and it's really a pleasure to be doing it again. It's something that I really enjoy, and some of you will know me from previous presentations and presentations direct to your own companies. So it's lovely to see some familiar faces back. And please do, at the end of the presentation, if there are any questions or comments that you have, please do let us know. Likewise, if you just need to get on, then you can always email me or any of us to raise those questions. I'm really pleased that my fellow maternity leave returner, Kate Lister, is with me. She's an associate solicitor here at IDR Law, and we're going to be talking to you about the first difficult stage after a death. Everybody on this call will have some connection to or will be working closely with recently bereaved individuals. It's something that we as contentious probate lawyers will have experience of even in these very early days. It can be tempting to think that the contentious probate side of things comes after a grant has been issued or after the will has been read, perhaps, or even further down the line. But sadly, we will receive these types of calls or contact from individuals where the death is very recent because they perhaps have had issues bubbling under the surface for some time. There might be suspicions that are coming out for them in the way that things are being dealt with pretty immediately after a death. But not least, it is an incredibly emotional time and a time at which the emotions are on the surface and very raw. So we can find that things that may not have been a concern start presenting themselves as concerns. And the aim of today is to talk through some of the key practical and legal points that people have to go through immediately after a death, and talk about how those can be triggers for a potential claim. We're also going to be looking at some of our own experiences here with individuals and cases that we've worked on, just to offer an extra level of insight on how we manage those and to give that perspective so that you in turn can help your clients if they are raising potential claims or potential issues at the very earliest stage. So what we're looking at today are amongst the myriad of issues that come about after somebody has passed away. We're looking at the sort of four main practical steps that need to be taken. We're looking at the will and who is entitled to administer the estate, who is in charge, who is the person dealing with everything. We're looking at the registration of the death and particularly the new role of medical examiner and how that fits into things and how this might be an extra layer of comfort or support for those who are recently bereaved. We're looking at the funeral arrangements. This is a key and significant trigger for disputes, not just disputes over the funeral and the burial, but actual disputes over the estate later. They can be a trigger for those types of issues and can bleed into that process and make things harder and harder to reach a peaceful resolution. Finally, we're looking at the stuff, the chattels. We call them chattels. Every time I speak to a client and say the word chattels, they look at me like I'm from the Middle Ages, but it's something that we use to describe the things that they possessed and the things that they cared for very deeply quite often. These items will hold meaning and importance and significance for the bereaved individuals. And so we've got to look at what can be done with them, who is in charge, and how that can also be a trigger for a dispute later down the line. What we're looking at today is really potential claims, potential issues, and what we want to achieve by the end of it is to give you that broad overview and to give you those red flags to look out for. Ultimately, we want to be able to provide as much reassurance and support to clients in this very difficult period of time as possible. What we see is that the practical aspects that they need to deal with are often a crutch and a structure to get them through to the funeral. And then after the funeral, there is a fast sort of spiral out of this structure and this these practical steps. And so dealing with these aspects in the right way and with sensitivity to all concerned is hopefully a way to mitigate any disputes later down the line. I am going to hand over to Kate just to talk us through what we do in those early days about looking for the will, what investigations need to be carried out, and then really who's entitled to see it in either scenario pre-grant or post-grant. So Kate, over to you.
Thanks, Helena. So like Helena said, looking at our first steps in trying to find a will, it's usually one of the first steps after someone's died to determine whether they left behind a will or whether the estate is intestate, and then the rules of intestacy are going to apply instead. Prior to someone's death, they might have informed their loved ones, or they might that they've made a will and that this is with their solicitor, or it might even be in a safe place at home. The starting point is to obviously check with a deceased person's solicitor or will writer that they might have mentioned, someone that they've had some contact with and you're aware of. Or, you know, if you have access to the deceased home, if it's a loved one, go in and have a look, see if there's any obvious places where it might be. You could also try checking with the deceased bank. It's not, you know, it's not that common anymore, but it is something that can happen. Or, you know, chat with family and friends. Has the deceased mentioned anywhere that they've used, any companies, online, in person, anything like that. If you know, that doesn't get you anywhere, you're unable to locate the will, then your next step is to consider a certainty search of the National Will Register. This means with this search, you can search for both registered and unregistered wills. It's unregistered wills within a set radius of a last known address. And it's also quite a useful tool as well, even if you have located a will, to still carry out a search of the National Will Register, just to make sure that there are no later valid wills than the one that you've already found, just to make sure that you're administering the estate correctly. If all searches have been completed, no will's been located, then you might presume the estate is intestate and the rules of intestacy are going to apply. In cases where there is a will, you might find yourself either needing to request sight of that will, or at the other end of the request from deceased family or friends or people who think they might be beneficiaries of the estate. Whether someone is entitled to see that will depend on how far you are in with the administration process and whether or not a grant has been obtained at that point. Before a grant of probate is obtained, the executors are entitled to see the will. You may find that beneficiaries or other people are entitled to see the will as well, but that's only with the executor's permission. And then once the grant has been obtained, the will obviously will then become a public record, and that means that anyone can obtain a copy of the will and the grant from the probate registry, as long as they paid the appropriate fee. I think at the moment it's £1.50, it's an online search, and then you'll get a link in an email to download the copy of the will and the grant.
Thanks, Kate. It's interesting because we are contentious practitioners, but we have these sorts of inquiries come through to us pretty early on, and so we often find ourselves giving this advice, you know, telling people where to find the will, telling people what to do, but it almost sounds obvious, but it is the appointed person who is in charge of the estate, who has to sort of deal with it. So we've got to find out the identity of that person. We've got to make sure that we know who is in charge. And so this detective work is really important. And particularly, as Kate says, making sure that we're not only looking for the will, but we're looking for the latest will. People go through changes in their life, family changes, marriages. They go through, times of wealth and poverty, and change their will accordingly. So we've got to be mindful of what the latest position was from the deceased. And likewise, there will be plenty of occasions where there are individuals who have an absolute hatred of lawyers and do not want to set foot in a solicitor's office to make a will. They may never have made one. They may have gone to WH Smith to buy a homemade will kit. They may have looked online for some service or other, but ultimately it's about doing that digging, doing that investigation, and asking questions, of the people who were closest to the deceased. It is still sadly the case that plenty of people just never talk about their will or what they want. They perceive it as very private and confidential, and they don't necessarily want to spark early disputes. But in our experience, if you talk about it and tell people where it is and explain what you've done, that can be a real salve for those early reactionary issues about what is written in a will. So we've just given you a little summary there on that slide about where to look. But the upshot is, this is such an important consideration because it is the person who is in charge. And this is why we've touched on this first, because as we will see later in the discussion today, it has the potential to provide certainty on the way in which things will be dealt with. But it also, as with any situation where there are conflicting views and opinions, leaves room for arguments and leaves room for additional conflict. But handled well and properly, and hopefully in advance by the deceased, it can provide the certainty that we want it to. Moving on then to another practical aspect or a practical step to be taken after death, which is the registration of the death. Usually this has been done before we become involved, and really this is something which we don't tend to have real involvement with, but I've summarised who is entitled to register a death here, and I wanted to touch on something that is new to us here, because even though we don't have the direct dealings with this process, it is the trigger for the arrangements of the funeral and for there to be an acceptance and the beginnings of moving on, where perhaps there's been a sudden or unexpected death, or there's been a death under difficult or unusual circumstances. And this is the introduction of the role of medical examiner. So the medical examiner sits independently to the person who certifies the death, which is usually the GP, unless they died in hospital. And this role adds a layer of, it adds a layer of, I suppose, closer scrutiny and transparency in the identification of the cause of death and any circumstances that surround the death, which need to be either referred on to some other body or to the coroner, perhaps. And it is designed to allow greater dialogue and opportunity for dialogue between those loved ones left behind and those responsible for this provision of this certification, and who may have been involved in the deceased's care right up to their death. the aim here is to allow for questions to be raised, for any concerns to be escalated quickly, which in turn provides ideally sooner closure and finality to a position for those bereaved. Naturally, it will not be able to address every concern or concerning situation, but the aim here is to give that additional layer where those concerns can be discussed and understood. So we'll see how that works out, and it will be interesting, you know, in talking to some of the attendees here today, and you know, when we're working alongside you, it'll be interesting to see whether you have any specific feedback from clients about their dealings in this way, and whether it did actually provide that additional layer of comfort, certainty, finality that it's designed to do. So moving on from that, we look at in my view, the biggest and most significant trigger for disputes after death, and that is the funeral arrangements. Ultimately, we're looking at who is in charge of making these arrangements. We're looking at potential pitfalls here, and we are considering how the court ultimately looks at and deals with these types of disputes if it is asked to become involved. It is a very common instance, you know, to see these types of disputes. In an ideal world, of course, everybody would agree the arrangements in advance, and the deceased would have made their wishes clear, and everybody would agree. But if it isn't handled carefully, it can escalate. My own view is that people will always remember what happened at the funeral, how it was handled. If it can proceed smoothly, peacefully, this can be a huge benefit, even if there is legal issues later down the line. And sometimes this cannot be helped. You know, you can have a beautiful send-off, but a contested estate nonetheless. So it is not directly causative, but it's something that can help to smooth relationships between the family members and those loved ones. So let's take a look at it in more detail. Let's have a look at the legal positions and looking at why these types of disputes arise and how the court looks at them. Back to you, Kate. Thank you.
Okay. So, although claims relating to burial disputes don't appear in the court very often, disputes relating to funerals, burials, cremations, etc., are really common, and they are something that we do become involved in the early stages. I mean, it could be that the deceased has died intestate, so there's no record anywhere of what their burial wishes, funeral wishes might be. You know, the deceased family or personal representatives can't agree on, you know, the correct provisions to be made, or it might be that the deceased left a will with quite clear instructions, but those instructions might not reflect discussions that have been had you know, before or after that will was drafted. So you end up with lots of people at one of the worst times of their lives, all with different ideas on how best to move forward. And then quite often they're all at loggerheads and nothing can happen. So in those cases, perhaps, you know, you may need to ask the court for directions, but it's, you know, like we said, it's not common that cases like this end up in court, but they are regularly dealt with by solicitors. It's important though to consider what the legal position is, and the general rule is that there's no property in a corpse. A body can't be gifted or disposed of by a will, and it can't be bought or sold. However, statute does permit that a body or part of it can be donated for medical or science purposes. But it's generally accepted that the purpose of a will is to deal with the disposal of property. And since a body is not property, the deceased person's wishes are not legally binding or capable of being enforced. So although, a will may say that I want to be buried here, and this is what I want to happen on that day, an executor doesn't have to proceed with those wishes. And sometimes it's not possible to either, because that will could be 20, 30 years old and those wishes are no longer possible to carry out. But it does mean that funeral and burial instructions, whilst they're not binding, it means that an executor will always have, or should always have, the final say. Although it is, of course, sensible that if a personal representative or executor, whoever, is aware of the deceased wishes, and those wishes align with the loved one's wishes, that it might be sensible just to proceed on that basis, to avoid any sort of unnecessary disputes, if possible. But where it is necessary for a claim to be issued in the court, each case is going to be determined on its own facts, and its success will be dependent on whether those facts give rise to what are called special circumstances, under which the court might depart from the general rule that the personal representatives are responsible for making the arrangements. The most recent case law on this was a case from earlier this year. It was Atkinson and the Co-op. In this case, the applicant Bernadette made an application for an injunction preventing her late father's body being cremated under the instruction of his executor, who was the deceased's other daughter, Nicole. The judgment confirmed the legal position that there's no ownership in a body, that where there's a valid will appointing the executor, then that's the primary responsibility to determine how the body should be dealt with is with the executor. In doing so, it's entirely appropriate for the executor to take into account and indeed attach significant weight to the wishes of the deceased. Bernadette's position was also that the will was invalid, and that the cremation would be against the deceased's express wishes and beliefs. However, in the judgment, the judge concluded that the will appeared valid on its face, and that Bernadette's allegation that the will was not valid and it was in fact fraudulent would need to be properly considered at trial on the relevant evidence. And then Bernadette was actually given directions as to what evidence needed to be put forward if she was going to proceed on that basis. But it is important to note that in this case, there was no finding in relation to the validity of the will. It was just the court's position that the will was reasonable and therefore appeared to be valid on its face. And it was the court's position that actually the body should be disposed of properly, with proper respect and decency, which they interpreted as meaning without further delay at that stage of proceedings. The court ultimately dismissed Bernadette's application for an injunction, and they concluded that the will appeared regular and rational on its face and expressly directed Nicole to continue with the funeral arrangements that she had made, which was to proceed with the cremation. And I believe they actually ordered some additional directions to allow the claimant Bernadette to sit with the deceased body before any cremation took place, which is it's a bit unusual. They don't often always make that sort of discretion for a claimant, but it felt it was right and fair in the circumstances. But ultimately, the thing to remember when dealing with any sort of burial or cremation dispute is that it's usually the personal representative who will be responsible for making those arrangements. But of course, you may always need to apply to the court if that's not suitable in the situation you're in.
Yeah, absolutely. I mean, we're talking about potential pitfalls here. You know, as you've said, the deceased's wishes don't have any weight at all here, save that, you know, that there is there's some good sense to trying to follow them. but that needs to be balanced alongside the wishes of and the expectations of loved ones. We've listed out these pitfalls here, which are relevant and important, because executors don't necessarily have to be family members. They can be professionals, they can be neighbours, they can be friends. There might be multiple executors, and that, you know, can be very difficult to balance, where, you know, perhaps there's you know, a mixture of friends and a loved one. The named executors, or even the person entitled to take a grant on intestacy, may be absolutely the wrong person to do it. You know, if you have a situation where there is a former spouse and they, you know, have never divorced, the deceased, it may be that they are the person entitled to take a grant and make decisions, but quite wrong for them to actually make those decisions in the eyes of those who are currently closest to the deceased. Some practical aspects: how much can be spent on a funeral? If it's all clear who decides, and you know, there's a nice rational will to follow, but there is no guidance there, you know, the beneficiaries of the estate may feel a little aggrieved by an extravagant, expensive funeral, if the estate, it doesn't warrant it, if it's not proportionate. So really, you know, we come back to this point about communication, being transparent, talking to the beneficiaries, talking to you know, those who are concerned and have opinions about what needs to be done here. It doesn't mean that the executors, personal representatives, need to follow those to the letter, but giving people the opportunity to be heard and to express their opinions is right in the circumstances. Just talking about funeral directors for a moment, because they tend to be the ones who are on the absolute front line of difficult emotional disputes between family members about funeral arrangements. They may have you know, heated discussions taking place in that first meeting where decisions are being made. They may find themselves being approached by somebody who actually doesn't have the authority to make the decisions, but is deemed next of kin, and therefore there is an assumption that they are entitled. In our experience, funeral directors are so keen, and so you know, it is paramount to them that the service is as respectful and peaceful as it possibly can be, and that it allows the loved ones and the mourners to attend and have that experience of saying goodbye. They do not want there to be overt disputes or, you know, poor conduct at a funeral, which might lead to difficulty or you know, people not being able to say goodbye in the way that they wish. They will do all they can to keep those disputes outside of the service, but legally sometimes we need to write to them to explain who's who and what the you know, what the proper authority is in this particular situation. And in our experience, they want to work with everybody to make sure that it is done properly and with absolute due respect to the deceased and to the loved ones. I wanted to pick up just on something at this point about the Atkinson case, and something which we will be contacted about frequently, which is there is a will and it names somebody as executor, but there is a suggestion that it is invalid, and there is a great deal of concern about the decision-making capability of that named executor in this purportedly invalid will. This was the circumstances set out in Atkinson, where there was a concern about the validity, but actually the judgment makes it clear that at that point there was no way that the court could examine the validity of the will or delve into it in any way, and that it would have to be a separate later hearing that covered that. The court did explain what it needed to be able to consider it, but the overriding issue it was dealing with was the funeral arrangements, and they needed to be made quickly, and the disposal of the deceased's body needed to be done respectfully and with dignity, and that was the point that was being made. But I know that, Kate, you've seen this as in as much in as many situations as I have, where there are these sorts of arguments, and we have to sort of explain the process really, and say it isn't something that we can sort of prove immediately. It's lengthy, and steps have to be taken.
Yeah, it is. And I think in with the Atkinson judgment, it is really clear that where there are disputes about the validity of the will, there is a set process to follow. We know what that set process is, but we know that it could take possibly up to years for a case about the validity of a will challenge to get to trial.
Yes.
It's not days or weeks that you need it to take in the circumstances of where you've got a body waiting to be disposed of respectfully. So it does seem quite reasonable in this latest judgment that the court has made directions for the body to be disposed of without further delay, but then also providing the applicant with it's actually set out as bullet points of what needed to be provided if she wanted to proceed in challenging the validity of the will. I think that was a good and fair way to set that out for them.
Absolutely, and affording her the opportunity to go and sit with the deceased prior to the cremation is an exceptionally sensitive and unusual order from the court, which it demonstrates the way in which the court looks at this. It has to be about balancing everybody's concerns and interests here, not least the need to for people to be buried or cremated in a dignified way, but also those very deep running issues. People do not make applications to court lightly, and this will have come from a place of very real concern from the claimant. So allowing her that opportunity, I think, was a very decent way of dealing with things. It occurred to me that we have situations which we are setting out here where there is a clear person in charge of making decisions, but who is facing a challenge. But we also see situations where there is more than one person entitled to make those decisions. And I mean situations where there are perhaps multiple executors, but also in the case of a death of a child, each parent has equal right to make decisions. And I wondered, Kate, if you would share experiences of a case in which you have acted where there was a death of a child in very sad and tragic circumstances, and how that was managed.
Yeah, so we were involved not that long ago in a dispute of the body of a young child who had lost their life. Both parents were being held in police custody for different reasons. The mother had already committed a previous offence and she was still in custody at the time of the child's death. The father and his partner at the time were being held related to the child's death. The father's family wanted to make plans for the funeral and the burial of the child, and they contacted the coroner to request that the child's body would be released to them. Understandably, the mother didn't want to relinquish that sort of control to the father's family. Although we appreciate it, it's not them who were involved at that stage of in his death, but she quite rightfully wanted to make those provisions herself. Ultimately, at the time of the body being released, both the mother and the father of the child were both equally entitled to obtain a grant of letters of administration to become the personal representative of the child's estate. That would mean that they would then have the control over the release of the body and the funeral and service arrangements. In order to ensure that they were the people who would deal with the release of the body, the father's family had actually lodged a caveat against the estate to prevent the mother from obtaining a grant. And I won't talk about caveats now because I know that's something we're going to discuss at a future
Yes, we'll be talking
clinic.
about that in the next session.
So I'll leave that for then. But ultimately, where a caveat is in place, it will prevent the entitled person from obtaining a grant at that time. We became involved and managed to successfully remove the caveat, which allowed the mother to then proceed and obtain the grant and become the personal representative of the estate. That meant that she could then secure the release of the body to herself, and then for herself to arrange the funeral, the service, the burial, in a respectful way that she wanted to do. But I mean, it's a really sad case. It was really difficult for all of the parties involved. But it is again another example of the law providing the authority to the personal representative of the estate to deal with the body and burial, funeral arrangements, everything that comes under that umbrella.
Yeah. Okay, brilliant. Thank you for summarising that. I think that gives a really clear insight into practically how things, can pan out and the difficulties that can be faced, just depending on the circumstances that arise. Moving on now and looking at the deceased's possessions. So we've talked about that the fact that the deceased cannot direct what happens to their body after death. They can direct what happens to their possessions, but it is, in these days of a lot of consumption by us, we have things in our houses that we are not going to make a specific gift in our will of. So we're talking about the house contents. This might be precious collections, it might be valuable family heirlooms. It might be something very domestic and mundane, which provides a reminder of the deceased to somebody and may have very significant sentimental value, but no real value at all. But this is now talking about what those items might be, and who is entitled to them, how they should be dealt with so as to mitigate the chances of dispute. So I mentioned right at the beginning the medieval phrase of chattels, and that this comes, this is something that we are so used to saying. But Kate, give us an explanation of what chattels are.
So like you said earlier, they are the personal belongings of the deceased. This could include anything from the kitchen pots and pans to valuable artwork, cars, jewellery, and in one case that I dealt with included a really large collection of ceramic pigs. But they may not have had much monetary value, but they were really high in sentimental value. You've often got to look at who's entitled to deal with all these assets, because like we said earlier, the executor might not be a relative, they could be a professional. So it's looking at who's actually entitled to deal with them. It is always still going to be the executor or personal representative of the estate who's entitled in the first instance to deal with the personal belongings. It's not uncommon to see specific gifts, particularly jewellery, watches, very expensive pens, ornaments, artwork, things like that, left in the will under a specific clause. Where that hasn't happened, and obviously it's not always the most practical way to deal with it, because you could end up with wills with 100 pages long with lists of every individual item that you've owned during your lifetime. So it's not always practical to do that. In those sorts of cases, the chattels might often be valued and sold, and then those funds will fall into the residuary estates and then distributed in accordance with the terms of the will or the rules of intestacy, after payments of liabilities, tax, that sort of thing.
Brilliant. As you say, this is something which is you can already see how this might create some difficulty where there are items of value, but also items of high sentimental value, and those left behind often attach significant meaning to some items. Likewise, those left behind may just want to sell everything and split the money between them. It just depends on the specific circumstances. But just to give you an overview of responsibilities in this situation, so taking aside any question of who is entitled to deal with the estate, if that person is clearly named, there's no dispute there, they have responsibilities on how to deal with the estate, not just the big ticket stuff, but the possessions, the contents of the kitchen, the contents of the bathroom, everything in the house needs to be dealt with. So rather than just bagging everything up or calling in the house clearance company straight away, you need to be looking at identification of all the assets. It can be grouped together, it doesn't need to be 6 forks and 7 knives. It can be groups of things listed. Anything of value ought to be insured, because the people in charge of the estate have to make sure that they are preventing loss to the estate. So if there are precious works of art or some items of value which are not insured and then damaged, that can create problems later on. So they must be valued for insurance purposes, but also for probate purposes, so that estate accounts can be drawn up and be accurate for those standing to benefit from the estate. Just a brief note on firearms. If there are firearms in the deceased property, it would be hoped that they will have told somebody where the keys to the gun cabinet are. But otherwise, steps do need to be taken quite specifically about what happens to those guns or firearms after death. The police can be contacted, the firearms licensing department can be contacted. Temporary licenses can be issued pending decisions on what's going to happen to them. They may have been gifted in the will, but even if they have, they need to be secured before they are given in that way. So it's just something to be careful of. Likewise, they can be very valuable, and they can hold sentimental value as well. So they are to be treated carefully, not with respect to the legal obligations, but genuinely these can create some obstacles later down the line. So that's just a point to be aware of there. We've talked about this being a trigger. It's quite clear that even the smallest of items can be exceptionally important to those left behind, and be, sometimes the unlocking of a dispute or obstacle for those in charge of the estate. It can be as simple as a small gift or small memento from somebody who may otherwise be making a claim against the estate, because they feel that they've been left out or they feel disregarded in some way. This can be a way through that. There can be room for discussions and those agreements, so as to soften things and turn down the heat in those early days. Ideally, we would be looking to suggest to PRs to have discussions with the family and, if possible, allow the family to distribute between them anything of significance. That doesn't mean they're absolved from taking those valuations, insuring, or doing any of those other things to prevent loss, but it does mean that the ultimate recipient might be established at an early stage. Then they can be focusing on how to administer the bequests specified in the will. If things go wrong, there is a risk of personal liability. So if there's losses to the estate, there's potential for personal liability here. But otherwise, if things go wrong at this stage, and we find that arguments continue over what might be relatively low value items, disputes can very quickly become disproportionate on costs. You might have lawyers involved at an early stage, and those costs can escalate. The estate might find that it is having to spend money on defending claims or responding to claims by beneficiaries. That incurs costs and ultimately reduces the value of the estate. So for all concerned, it is something to nip in the bud and try to manage carefully before those possessions are put into bin bags and taken to a charity shop or the house clearance company is called in. In summary, today we've learnt that funeral disputes run very deep. They are significant. The events leading up to the funeral and the funeral itself is significant and will stay with people. We've also talked about the risk of a perception of the PRs going against the deceased wishes. If there is conflict there and conflicting ideas about what needs to be done, open and transparent early conversations can help to smooth things over. If they can't, then it can help everybody prepare for later disputes if they arise. This is also the case for not being as transparent or being as open in communication as you should be if you are a PR dealing with an estate. Keeping people up to date can make all the difference to their feelings of being heard and being valued, their opinion being valued in the administration of the estate. Finally, we've looked at chattels and how to manage them, what the responsibilities are, and how to best avoid disputes over items which can create disproportionate disputes and conflict later down the line. Thank you so much, Kate, for your really helpful overview of the case law there and the points that we've talked about. You're practically looking at finding a will, what steps can be taken, and also looking at the point about chattels and how to deal with them. Looking ahead to our next session, we will be going through the issues that can present themselves before a grant is obtained. So we're moving on from this very raw first couple of weeks, and we're looking ahead past the funeral. The dust has settled. Everybody is now faced with unstructured time to think. The practical steps have been taken. Now there is just, what do we do now? We still feel aggrieved. We still feel like we're not being heard. We still feel that something must be done. That is the point that we're going to pick up on next time. We're going to look at how to stop a grant being issued. So if there are very real, genuine, significant concerns over the grant being taken by somebody, or if there's a concern about the will, then we will go through the process there. We'll look at how people start to build their case. This is the time at which they are thinking about it and they are sitting and dwelling on everything. So we're going to look at that and look at how those can lead into the more substantive issues later down the line. Finally, before we go, I wanted to let you know about a really exciting new initiative through the IDRN. It's called IDR Intel. Every month, Stephen Lawson, one of our partners, is going to be coming and talking to everybody about anything that is relevant and that you need to be updated on. This content isn't going to be anywhere else. This is going to be on the IDRN via IDR Intel. It is going to provide you with case summaries. You're going to have bite-sized training. There's going to be up to the minute information there, as well as our views and how we're seeing things in this sector. So it would be wonderful if those here today could go on to the IDRN. I'm going to ask Christian actually if he can pop in the chat a link to a survey that we've put on there, which asks you to give us information, give us input on what you want to see here, how you want these sessions to be weighted and really what you're looking for out of them, so that we can make sure it's completely tailored to those who are attending. Also, if you aren't already a subscriber to the IDRN, please do so. It takes a couple of minutes. It's completely free. And this is where you will find the recording of today's session. This is where you'll find slides for today, all the previous clinics. And this is where you will go to attend the IDR Intel sessions as well. Finally, from me, if you need a CPD certificate, please just email Christian or myself. If you want to get in touch with any of us with any questions as well, just let us know. But for certificates, just give us a shout and we can send that across to you. But otherwise, we're just coming up to an hour. So I hope that you've enjoyed today's session and it's been useful and you're able to take something away from it. We'd love to see you next month. And thank you so much for your time today. It was great to see you.